Welcome back to another episode of Family with Judy. With me, I have Ken the drone guy and Judy, the family lawyer. So last time we spoke about estate planning, and Judy, you introduced estate planning to us. You told us there are 5 ways that a person can use to plan their estate, and we discussed about wills. So what are we going to discuss today?
So we're going to discuss the other ways in which you can plan your estate, and we will start with the joint ownership of property. What it simply means is that the owner of the property, the one who wants to gift the other, registers that property jointly in the joint names of himself and the beneficiary. And so that when any of them passes away, the property automatically goes to the survivor. We say the survivor takes it all, okay? And you don't need to go through the court process in terms of succession proceedings. It is enough that you produce evidence of the death of the joint owner to the registrar of lands or the lands registrar upon satisfaction that the other person has died, and that you're the surviving joint owner. The property will automatically be transmitted to yourself. So it's a very, very easy way of passing on a person's estate or property to the beneficiary.
You say automatically. What does that process look like? I mean, is it that because my spouse has passed on, then nothing needs to be done? And so
all you need to do is to produce evidence of the death to the registrar of lands or the lands registrar to confirm that the person with whom you held the property jointly has passed on. And without needing any court process, that property will be transferred to your name alone from the joint ownership. Because you see, when that does not happen, when that's not the case, then it means you have to go to the court, petition the court for letters of administration, go through the whole process, that you go in to succeed the deceased person's property, and then finally, at the end of that process, come back to the registrar and have the registrar register the transfer of the property in accordance with the court order. So this is the shortest, the least complicated of the processes.
I see.
Yes.
Can you give us an example of whom the beneficiaries could be?
Okay, so the beneficiary can be anyone that you wish to benefit from that property. Of course, usually we see spouses holding the properties jointly with one another, but it can be any other person. There's no limit to whom you can have as your beneficiary. That's completely up to you.
And in that case, so I'm thinking, say, 5 partners owned a particular property.
Yes.
And one of them passed on.
Yes.
So they have joint ownership.
Yes.
So the other 4, then would they share equally?
So here in joint ownership, what the law says is that if you hold jointly, one person passes away, the ones who are left continue to hold jointly, and so on and so forth, until the last person is left alone, and then they will leave it to their estate, But there is also something that we call, a concept we call tenants in common, which is different. In tenancy in common, it means that you are holding a definite part of that property. For example, Ken holds 50% and I hold 50%. In the event of my demise, my 50% does not come to you. It goes to my estate, right? In the event of your demise, your 50% does not come to me. It goes to your estate. That's the tenants in common as opposed to joint tenancy.
So what's the advantage of registering property jointly?
Okay, so for purposes of estate planning, the benefit is that you don't go through the succession proceedings in court. The property passes on to the beneficiary that you intended it to pass to without a lengthy court process, which is involved in other succession proceedings. It means that it's cheaper in terms of time, in terms of money, and in every other respect. And then you, as a person who's planning your estate, you are certain that the property will go to the person that you intended it to go to. Nobody else can come in between. It's a given.
All right.
Yeah. Mhm.
And I guess from there on, the next one would be gifts.
Yes.
And I think there are multiple categories of gifts, but if you could elaborate a little bit.
Okay, so there's two main categories of gifts. One of them, under the law of succession, we call it gift intervivals. What it simply means is gifts given during your lifetime. Okay, and that means that the gift is passed on during a person's lifetime. It is definite, it is clear. So you could transfer a piece of land, for example. I think we are talking about land or shares.
Oh, we like land.
To another person. That's what we call a gift given during a person's lifetime, or a gift intervivals. It's a fantastic way also of estate planning, because again, it's definite. It's moved on to the person that you wished it to go to, and it's complete, by the time you die. Okay? Then there are forms of gifts that we call gifts in contemplation of death. These are interesting.
So, gifts during a lifetime. So, for example, I'm alive.
Yeah.
I want to give this to somebody when I die.
Yes.
Right?
Yeah.
But
No,
I give them a land.
you give it during your lifetime.
Yeah, during my lifetime.
Yeah. Yeah. Aha. That's an interesting one. Actually, that's an interesting distinction you've just brought in. Yeah.
The fact that I've given it to you, is that, are we already in succession planning at that point?
Okay.
You see what I'm saying?
Yeah.
Because I'm still alive. I'm still very... I mean, I can decide to gift your land, but does that mean at that point now you take ownership, you start using it for whatever you want you build on it? Or is it in the event of my death that then you take ownership?
In estate planning, you are planning for how your estate or asset will pass on to your beneficiaries or those that you wish them to pass on to. So you've got to be living to do estate planning. You see?
Sure.
Okay? If you're not living at the time, if you're not living, you cannot do estate planning. That's the difference. So you can gift during your lifetime. And you can pass on that gift completely to the person you wish it to go to, your beneficiary. It's a piece of land, okay, a motor vehicle, whatever it is, transfer it to that person. And the gift is complete during your lifetime. It does not depend on your dying. Okay. But the joint ownership, you have made that person a joint owner with you. The gift will only pass on to them completely upon your demise. That's a difference. Okay. Then the wills also. You have made a will and you have said, in the event or upon my demise, I want these properties to go to so and so. So for those ones, you need to die so that the gift can pass on. But these ones now of gifts during lifetime, they're complete during your lifetime. Then we have gifts made in contemplation of death. So your death is imminent. You think you are dying, okay? And you give somebody a gift. Usually what we call movable gifts, a vehicle, a phone, okay? And you give them because you're anticipating death and it's imminent, and on condition that if you don't die, they give the gift back to you. But you deliver possession of that gift. If you die, or when you die, the court will honor that gifting.
And I know we spoke about a phone and such smaller items, but back to our favorite subject, land.
Yeah.
If you gift a land on somebody's deathbed, what does that look like as far as
land is different. This is a
Okay.
movable, so it's a vehicle.
So, okay.
It's movable items.
Okay.
Vehicles, these cameras here that we're using,
Okay.
this coffee table,
Okay.
your laptop.
So gifts with
Yeah.
I'll call it deliberation because
Yeah.
well, the expectation of death
Yes. Should
have
be
to be
movable.
movable.
They should be movables. The others, the land and others, you can only do that either through a written will or spoken will.
Interesting.
You see? Yeah. Or registering them,
Wow.
joint ownership or transferring them during your lifetime. Yeah. Yeah.
Is it correct to? Is this statement correct that gifting? So, the oral wills. I do not give you the whatever it is that
Possession, of the
you don't
item.
get possession until my demise.
Yes.
Versus
Yeah.
gifts with
Yes.
expectation of
Yeah.
death.
Yeah.
I give you the gift, and you stay with it. If I don't die, then I
Yeah.
can come back for it.
Okay,
Is that okay?
completely. So in the oral will, you say, upon my demise, you will take 1, 2, 3. So then I have to be demised, so to speak, for it to become yours. In the gifts in contemplation of death, I am giving you a gift on condition, it's conditional, that I die from whatever it is that I'm anticipating to die from. And on condition that if I don't die, you give back the item to me. But also, it is a condition that you must deliver possession of that item to the beneficiary.
I think the next one will be nomination.
Yes, indeed. So, nomination is also a way of estate planning. It is a direction to a person who holds a fund on behalf of another person to pay that fund to a person nominated by that other person. So you hold a fund on my behalf.
Yes.
And I tell you, Kogi, I direct you to pay that fund to that other person in the event of my demise. So it happens in insurance policies. It happens in circles. So they're holding the fund on your behalf, but you have told them, especially at the beginning, many of us are asked to sign forms, that in the event of my demise, I'm directing you to pay the fund to another person. That is a nomination. Many circles also ask for that. It is a way of estate planning, and it's very powerful. And by the way, many of us at some point in our lives have signed that form. And it's very important for people to remember that they need to check who they nominated, because it could be at the beginning of their work life. And at that point, they probably didn't have families of their choice. So they may have nominated their moms, their dads, or their siblings. So it becomes a challenge when that person passes away without having changed the nominees, yet they had families of their own choice. So it becomes complicated. So something that we keep telling people, check who your nominees are. But I think the greatest challenge is where you have nominated a significant person, perhaps a spouse, and then that story ends in divorce. So if you do not change your nominee, guess who will laugh all the way to the bank? The spouse that you nominated.
Yep.
So it is a key way of estate planning, and many of us have it in place without thinking about it. But we do need to be intentional and to be conscious about who we want to benefit in the event of our demise.
Please take us through trusts.
Okay, so it's another way of estate planning. It's created where a property or an asset is held by a person or an entity on behalf of a beneficiary. Trusts are not as complicated as they sound. It simply could mean that I, for example, being a registered owner of a property, could move that property from me as Judy to me as a trustee, holding in trust for myself and my children. See what I mean? So the title then reads, Judy holding in trust for herself and for her children. So I become the settler because I'm the one who has settled the property into the trust. I also become a trustee because I'm holding the property in trust. I'm also a beneficiary because I am also a beneficiary of that property. Okay. Upon my demise, then the property goes automatically to the ones who are left. If it's my children that I have named, the property automatically goes to them. So that's what holding in trust essentially means. It may be an individual. It could also be an entity, a trust created under the law to hold an asset, to hold income or other properties on behalf of third parties.